are judicially discoverable and manageable standards for resolving the matter. Number 3, whether it is impossible to decide the matter without making an initial policy determination of a kind meant for non-judicial discretion. Number 4, whether it is possible for the judicial branch to make determination on the matter without expressing lack of respect for the political branches. And the 5th principle is the multifarious pronouncements by various branches of the government on the same question would be embarrassing. I don't want to belabor what my teacher, Professor Milimani Law Courts, ably helps this court with from page 419 of his text, Administrative Law text, Strathmore University Press, 2016, 419 to page 423. Professor Migai counters the narrative of the political question doctrine and its applicability in Kenya. Specifically, these factors have stirred controversy even within the US context. So if they start controversy within the US context, why would they be applicable to us? That is one. The political question doctrine purports to create a dichotomy between political and legal questions. In the US context, as evidenced by Professor Milimani Law Courts, the US Supreme Court itself has consistently invoked prudential and constitutional factors in its determinations. So legal factors are front and center in determining what are so-called political questions. The Baker factors that inform the political question doctrine make an unrealistic assumption that there is an existence of political and legal questions that can be neatly separated in the context of litigation before this court. We say no. The political question cannot be applicable within the context of the Constitution 2010 for the following reasons. Number 1, this Constitution, Constitution 2010, creates a supervisory jurisdiction for this honorable court, and that supervisory jurisdiction anchors not only on Article 165, but is anchored also on Article 1, Article 2.1, Article 3.1. So if courts decline to decide cases on the basis that they are political, courts would be abdicating the very role that their Constitution, our Constitution, imposes. The Constitution expects the courts to review all exercise of public power, including politically sensitive ones. For that regard, I refer the court to the lead decision of Professor Justice Joel Ngugi, as he was known then in the David D decision. He emphasizes that point. Second reason why this doctrine is not applicable to the Kenyan context, this doctrine is incompatible with the broad discretionary authority, jurisdiction authority rather, granted to this court under Article 165. So anything done under the authority of the Constitution, including impeachment, including actions of Parliament, the President and political actors, are amenable to review. There is no constitutional exception for political questions. Number 3, the tenor of the Constitution 2010 indicates that we are dealing with a transformative constitution. And transformative constitutionalism rejects judicial abstention. Kenya's constitution has been widely described as transformative. It is meant to dismantle the history of the executive dominance, impunity, and weak judicial oversight. Before 2010, it would have been prudent for the courts to avoid politically sensitive disputes. The executive power was rarely checked. After the Constitution 2010, the Constitution deliberately expanded access to courts through Article 22 and Article 258. Standing rules were relaxed to ensure that all matters, including political questions, are amenable to judicial review by this court. To allow or to even countenance the political question doctrine would be to recreate the pre-2010 culture of judicial avoidance that the Constitution sought to end. The fourth reason, the Bill of Rights demands that judicial enforcement happens against the state. Article 20 of the Constitution requires that courts apply the Bill of Rights to all law and to all state actions. Human rights violations always arise from political decisions, elections, public finance, security policies, legislative processes. So if courts were to label such issues as political, fundamental rights will become unenforceable whenever violations arise from political power undermining the Bill of Rights. So in examining the impeachment process, there are rights questions that are involved, and the Constitution empowers you to exercise judicial review. The fifth reason why that doctrine is inapplicable is separation of powers in Kenya requires judicial engagement and not abstention. Kenya adopts a checks and balances model, not strict separation. The judiciary is designed as an active counterweight, and the Constitution explicitly allows the court to do the following. Number one, review parliamentary procedures. That is empowered under Article 124, Article 165. Review presidential actions, to issue orders against the state. That is by our Article 23, which is our remedial clause. Thus, the judicial review is a structural component of separation of powers, not a violation of it. Sixth, constitutional design anticipates politically sensitive disputes. The Constitution directly assigns the courts the role to delve in deeply political processes, such as political election disputes, which are political, impeachment processes, governance, and the like. Courts are allowed to delve into them. Constitutional amendments, we dealt with this during the BBI. Public participation in legislation, these are politically sensitive issues that the court is allowed by the Constitution to delve into. So if it was not intended for the courts to delve into, these items will not have been explicitly placed in the court's hands at the center of these processes. The court will not have been allowed by the Constitution to delve with these issues. Number seven, popular sovereignty requires judicial enforcement. Under Article 1, all power is delegated by the people. Courts act as referees, ensuring that delegates remain within constitutional limits. When you conduct the process of impeachment, and we say that impeachment is a constitutional process, a constitutional interrogation, you are exercising power that is delegated to you by the people. And therefore, if courts refuse to decide political disputes, there is no neutral guardian of the people's sovereignty under Article 1. Political branches will become judges in their own course. That outcome contradicts the entire constitutional architecture. So, finally, and in conclusion, with regards to the political question doctrine, the Constitution mandates judicial review of all power. All power. It entrenches transformative constitutionalism. It constitutionalizes public interest litigation and broad standing for the purpose of checking power. It assigns the courts roles for engaging in politically sensitive processes. And finally, it requires this court to enforce the Bill of Rights against the state. Public participation. Public participation is a public engagement that is enshrined as a national ideal and a governance principle under Article 10(2) of the Constitution. This clause emphasizes the necessity of engaging individuals in decision-making and guarantees that their perspectives are taken into account on issues of public significance. Public participation has also been incorporated into domains of governance, including Article 69, which mandates the state to promote public participation in the management, protection, and conservation of the environment. Article 118 mandates Parliament to promote engagement and participation in its legislative procedures and other parliamentary activities encompassing functions of its committees. Therefore, public participation cannot and is not a procedural formality that can be exhausted by one institution on behalf of another. It was the position of the Senate that the Senate did not need to conduct public participation after the National Assembly had done its bit. We say this, that public participation is not a procedural formality that can be exhausted by one institution on behalf of another. Rather, it is a constitutional principle embedded in the architecture of governance under Article 10(2) of the Constitution. And as a national value and principle of governance, public participation binds all state organs whenever they exercise constitutional authority, including the Senate. Consequently, the Senate could not and cannot validly argue that public participation conducted by the National Assembly was sufficient to satisfy its own constitutional obligations during the impeachment proceedings against the Deputy President. The National Assembly and the Senate are distinct constitutional organs with separate mandates, separate procedures, and deliberate responsibilities. So while the National Assembly initiated and investigated impeachment proceedings, the Senate was expected to exercise independent adjudicative and oversight role in determining whether the charges warrant removal from office. And since the Senate performs a constitutionally distinct function, it must independently uphold the constitutional principles governing the exercise of public power, including public participation. With regards to public participation, we had presentations here on the BAT case, equally on ex parte Gakuru, which denotes two tests, the qualitative and the quantitative test. In terms of the qualitative aspects of public participation, we pose the following questions, and we will want this court to examine whether the respondents really complied with the qualitative and quantitative tests of the Constitution, because case law from this court and the Supreme Court demand that those who conducted public participation must prove to your satisfaction that public participation mastered qualitative and quantitative aspects of it. So the following questions in terms of degree of inclusion. In the Gachagua impeachment case, these are the following questions. Were all constitutionally relevant stakeholders afforded a real opportunity to participate? That is the first question that this court should consider, based on what the respondents submitted. Second question is, were any groups directly or indirectly excluded, restricted, or unable to participate? And on the question of participation, the follow-up question is this: did the stakeholders get all the necessary information to capacitate their involvement in the public participation forum? Did they know what they were participating in? That is the third question. The fourth question is this: did any stakeholder voluntarily decline public participation despite being given the opportunity a fair opportunity to participate? Those questions will be important for this court in the context of public participation. And public participation not only has domestic constitutional connotations, but Article 25 of the ICCPR, the International Covenant on Civil and Political Rights demand that citizens must be involved in matters governance that necessitates public participation in the dimensions required by Article 25. Information given to them, their feedback given, their input taken into account. As I wind down, this court will be engaged in constitutional reading and interpretation. Chief Justice Brian Dixon of the Canadian Supreme Court, dealing with one of the first questions after the enactment of the Canadian Bill of Rights in a case called Hunter versus Southern Inc., 1984, said this, that the task of expounding a constitution is crucially different from that of construing a statute. A statute defines present rights and obligations. It is easily enacted and easily repealed. A constitution, by contrast, is drafted with an eye to the future. It functions to provide a continuing framework for the legitimate exercise of governmental power, and when joined by a bill or charter of rights for the unremitting protection of individual rights and liberties, its provisions cannot easily be repealed or amended. It must therefore be capable of growth and development over time to meet new social, political, and historical realities, often unimagined by the framers. The judiciary is the guardian of the Constitution and must, in interpreting its provisions, bear these considerations in mind. That is Chief Justice Brian Dixon, one of the celebrated Canadian judges in Hunter, Southern Inc., 1984. As Chief Justice Brian Dixon observed in this matter, the Charter of Rights and Freedoms, jurisprudence, a constitution is not a transient political instrument fashioned for the convenience of the moment. It is a living covenant designed to endure beyond the passions, the pressures, and the personalities of a particular age. Its guarantees are intended to outlive political majorities and to restrain the exercise of public power whenever expediency threatens constitutional fidelity. That duty falls most heavily upon the courts at moments such as this. The question before this court is therefore larger than the fate of any individual office holder. It concerns whether constitutional safeguards governing impeachment shall remain meaningful limitations on power or become pliable tools, vulnerable to political dissatisfaction, procedural shortcuts, or majoritarian impulse. If the constitutional threshold for impeachment may be lowered whenever circumstances become politically convenient, then the protections deliberately entrenched by the Constitution cease to be safeguards at all. They become ceremonial words devoid of normative force. Impeachment is among the gravest constitutional mechanisms available within a democratic order. Its exercise must therefore be anchored on strict fidelity to the Constitution, demonstrable evidence, procedural fairness, and scrupulous observance of constitutional standards. Anything else, anything less, not only imperils the independence of constitutional offices, but also public confidence and the rule of law itself. The Constitution does not permit removal by atmosphere, speculation, public pressure, or political arithmetic. It demands proof, legality, and constitutional discipline. This court now stands as the ultimate guardian of that discipline. Posterity will not merely examine whether a removal occurred, it will examine whether the Constitution survived the process intact. It will examine whether the Constitution survived the process intact. Future generations will look to this decision to determine whether constitutional restraints remained firm when tested by political urgency or whether they yielded to transition pressures. The enduring legitimacy of constitutional governance depends upon the court demonstrating that constitutional procedures are not optional and constitutional thresholds are not elastic. Accordingly, where the impeachment process fails to satisfy the substantive and procedural standards demanded by the Constitution, the court must say so clearly and without hesitation. To do otherwise would not merely occasion an injustice in the present dispute, it will establish a precedent capable of weakening constitutional democracy for future generations to come. The correct decision, therefore, is the courageous one, to uphold the supremacy of the Constitution over convenience, principle over pressure, and the rule of law over the impulses of the moment. I submit.
Thank you.
My Lord, please, I'm always taking 10 minutes. It is easier, he speaks fast. He comes from a community that they say is marginalized. He should be done fast.
And my lords, I'm fighting for that space so that I'm not marginalized.
You take 10 minutes.
Yes. My lords and my lady, my name is Ole Kamwaro. I'll be very brief because brevity and precision are demanded when the Constitution itself has been violated with such present clarity. My lords and my lady, what stands before this court is not a matter at the margins of constitutional law. It is a matter at its very core. The impeachment of the first respondent, His Excellency Rigathi Gachagua, as the Deputy President of the Republic of Kenya, was not merely procedurally flawed, it was a constitutionally hollow, it was legally fraudulent, and this court must say so plainly and without equivocation. My lords, the respondents have spoken before you and submitted before you, but there are pertinent questions that have not been answered and put across satisfactorily before this court. The question is, where in any court or in any proceedings before any competent authority has it ever been determined that Honorable Gachagua committed the offense of hate speech? The answer, my lords and my lady, is nowhere. And yet, on the basis of that finding, a deputy president was stripped of his constitutional office. That, my lords, is not governance, that is purge. Let me now go to the issues and offenses under Section 13, 1A of the NSAIC Act. And I'll start by saying that the allegation of hate speech is a legal nullity dressed in parliamentary robes. My lords and my lady, Section 13, 1A of the National NSAIC Act is not ambiguous. It requires a sine qua non words or conduct that are threatening, abusive, or insulting, and that either intend to incite ethnic hatred or likely to do so. I submit that both limbs must be satisfied. The respondents who spoke before you have not satisfied any of those limbs. The first petitioner's remarks, in part remarks that has rattled so many, on the issue of that majority of the people who voted for the Kenya Kwanza regime have a legitimate expectation of participation in structures, in state structures, are on any plain reading a political metaphor, a metaphor about democratic accountability, a metaphor that if one were to apply intellectual honesty to it, actually advances a thesis on the relationship between electoral mandate and governance access. One may disagree with that thesis that I submit, but disagreement with a political viewpoint, my Lord, has never and can never be hate speech under any known law in the Republic of Kenya. My Lord and my Lady, where is the ethnic group that was threatened by the implied speech of Honorable Gachagua? Where is the community that was insulted? You have not been told of any community. Where is the finding of ethnic animosity? My lords and my lady, there is none, because none exists. The implied speech named no tribe. It targeted no ethnicity. It incited no violence. To address it in the garments of Section 313 of NSAIC Act is an insult, not to any ethnic group, my lords, but to the law itself. And consider this, the National Cohesion and Integration Commission, my lords, is the body vested by Parliament under Section 25 and 26 of NSAIC Act with exclusive mandate to investigate, summon, and recommend prosecution for violations of Section 13. It's very conspicuous, deafeningly silent. That commission did not speak. Not one summon was issued. Not one caution was issued to Honorable Gachagua. Not one recommendation was made for his charging before any court. That very watchdog created to guard against hate speech refused, my lords, to back. Parliament chose to back in its place. And in doing so, Parliament exceeded constitutional canon. When Parliament, my lord, bypasses NCIC, and itself determines that a statement constitutes hate speech, a finding it has got no jurisdiction to make. It does not merely my lord, it usurps. And usurpation of constitutional or legal function is precisely the kind of excesses that Article 165 of the Constitution vests in this court to strike it out. My lords, the charge of hate speech under the sections that I have referred to is hypocrisy. Selective justice, my lord, is not justice at all. My lord, the respondents prosecuted the case against Honorable Gachagua for allegedly promoting preferential treatment on the basis of political identity. And yet this court must make judicial notice, and is entitled to do so, and is obligated, of public record appointments made by this regime after assuming office in 2022. And I'm speaking so as a lawyer who comes from the Maasai community that is marginalized. If you look today in our affidavit that we have filed, the statistics, the number of appointments that have been made or allocated to certain communities, if you compare the Maasai nation, the Mijikenda, as against others of similar numbers, they did not tell.
I think, just sit down, retrace your steps, please.
Most of it. So I'm saying that we have given figures in our replying affidavit. But I'm saying even those the appointments that are being made do not respond with without the Constitution talks about ethnicity, regions, and diversity of Kenya. This court must ask itself, if the law means anything in this republic, can it be applied only against those who fall out of political favor, while those who hold power are exempted from it? The answer from every constitutional and jurisprudential tradition is an emphatic no. My lord, we have submitted that Article 11, Article 56, on the issue of ethnic and cultural diversity of our country are provided for in that constitution. My Lord, you have been told much about the doctrine of restraint. I want to say this, that legitimacy of this court intervention and why restraint is not available here, and I say so. The respondents have argued before you on the doctrine of separation of powers and urged this court not to interfere with the parliamentary processes. That argument is a familiar refuge for those who have exceeded their authority, for it asks the referee to stand aside precisely when rules have been most violently broken. My lords and my lady, this court's jurisdiction under Article 165(3)(d) of the Constitution is not a courtesy. It is a constitutional imperative. When Parliament has acted beyond its constitutional mandate, and Parliament has no mandate to make findings of hate speech and bypass the NCIC to remove the Deputy President on grounds that do not meet the constitutional threshold, this court cannot. It's not intruding on parliamentary space. It's actually indicating the Constitution. My lords and my lady, the Supreme Court of India, in the case of Casavananda Bharati, and our own Supreme Court on foundational cases on constitutional supremacy, has established beyond doubt that no arm of government, not even the legislature acting by supermajority, may override express provision of the Constitution. Parliamentary immunity for judicial review is a doctrine of legislative acts within the constitutional bounds. It is not a license, my lords, to violate those bounds with impunity. This court must intervene. Not because it's eager to do so, but because the Constitution demands of you to come and save the soul of this Constitution. In conclusion, what history will record after these proceedings today? My lords and my lady, let me close by saying this. The impeachment of Honorable Gachagua will be recorded in the constitutional history of this republic. The question is, what record will say? If this court allows to stand the impeachment, the record will say that in Kenya, a deputy president may be removed from office on the basis of political metaphor without any finding by a competent authority and without meeting constitutional threshold and through processes that selectively targets political opponents while exempting those in power from the equivalent treatment, scrutiny. If this court grants the relief sought in our petition, the record will say something entirely different. It will say that in Kenya, the Constitution means what it says, that the threshold of impeachment is real and it is high, that the rule of law is not a slogan but a shield, available to every Kenyan, including a Maasai like me, including those whose politics are inconvenient to the powerful. We urge this court to make the right record. We pray for orders as prayed in our amended petition, including a declaration that the impeachment of the first petitioner was unconstitutional and an order that will be compensated as prayed. So I submit, my lords.
Thank you.
And always, my lord, whenever I speak and address this court, my learned colleague is my friend, always interrupts my presentation.
There was a petitioner in this matter, especially during earlier proceedings. No, I'm not addressing you. There was a petitioner in this matter, Senior Counsel Hamenwa. I have not seen him in this second arm of proceedings. Is the counsel well?
I haven't seen him. My lord, I think he came during the first PM there.
Yes, I have not seen him again, so I have no information. I think he was appearing in his personal capacity.
Yes.
And also for one of the civil society.
And my lord, now that that issue arises, is one of the senior lawyers I've had the privilege of calling me to tell me one or two things that have clarified some of the points.
Is he okay?
He's okay. I don't understand much, but he's okay.
All right.
Yes. Now, my lord, I'm happy for the time given to my learned colleagues, Mr. Martin Kamwaro, to deal with the issues because of the time constraints that are there. I will try to speak a little bit fast. I'm assuming you are being recorded.
Yes, taking how much? 30 minutes, eh?
Yes, I should be done between 30 to 40 minutes. Submissions that I'm responding to, if I don't mention any persons, it is only because I have had to edit the response to fit the timelines that have been accorded to me. Now, first of all, I want to thank this friend of mine, Dr. Mudomi, for mentoring this young lawyer that we had in making very good submissions. I told him he reminds me of Gibson. He mentored very many people, including myself. And I challenged my assistant, Sylvia Musongo, that if ever Professor Kindiki, who is my friend, also is impeached, he should come like Motegi to speak. Be that as it may, then we come to the business of the day. And I want to clarify, Mr. Mukele had suggested that the specific orders of standing orders of the National Assembly and the Senate have not been challenged. I want just to reiterate that we did so in prayers number 12 and 13 of the re-amended petition. And the next general issue is a cross-cutting issue that has arisen, is the questions of may and shall in our Constitution. I will not bother the court with the grammar, which appears differently in very many decisions from the High Court to the Supreme Court. Because we are dealing with constitutional adjudication, the Constitution has already said how the Constitution shall be interpreted. And that includes the word may and shall. In Articles 20, we start with Article 4, I believe. The second is a constitutional democracy. So you are in interpreting the meaning of any law. That's the value that you start, constitutional democracy. Values of our Kenya are stated in Article 10. And then we have Article 24, where they say interpreting any law or statute, any intervention by Parliament, they must take into account the fact that this is a free society that believes in democracy and certain value systems. That is in Article 24 of the Constitution. And then there is Article 259(1) of the Constitution that also says how you interpret the Constitution. So that bearing in mind those provisions, it is our submission that the context in which the word may and shall in Article 145 must be interpreted by the Constitution is by this court examining what is it that it seeks, what is the issue of substantive justice, substantive law that seeks to be secured. And my lords, I submit that the Constitution itself, when you read it, makes it clear that when the motion and the report is received from the National Assembly, Senate shall investigate the matter. Shall investigate the matter. The question is about investigations. In our earlier submissions, we said why under our system of justice and the adversary justice system, justice must be based on truth, and investigation is how you arrive at that truth. Therefore, if that be the case, then 145 must be read in a manner that upholds that an investigation must be conducted, because that is the principle and that is the value. The issues of natural justice, they are set out in our constitutions, must be incorporated in interpreting that law. So that, my Lord, there would be some danger, obviously, that if the usage of the word may, as suggested by the respondents, was to be used to say that you can actually impeach an elected deputy president without investigation, as the Constitution seems to say. Such a reading is absurd. But apart from the absurdity of it, is that it is unconstitutional on the basis of the provisions of the constitutions that we have read. But now, the only other question is a practical question, which is purely a question of common sense. My lords, why didn't the Constitution use the word shall? For the simple reason that historically, because we have imported this impeachment issue, it is not every time that when the National Assembly has impeached a president, like they do it in America, that the president would actually agree to have the trial. So what that means is that you couldn't use shall because if, for example, you are dealing with an American situation, Nixon did not go for trial. Nixon resigned. So that it becomes now an optional issue that at the time when the matter is at Senate, it would have to be dealt with in a prudent manner. What is the prevailing situation? Just like now when you are dealing with the prevailing situation, the lawyer for the first respondent have not said, are saying, though the Constitution can reinstate the first petitioner to office, they are nonetheless saying, why we may not go take that office. So that, my Lord, because of the possibilities of all those intervening, is the reason why you use the word may. Many statutes that I know, I've done a lot of work on these university statutes. There are very many cases starting with Superchachi. I believe I even defended Hassan Omar when they were trying to get him out of Moi University. My Lord, many universities would use the word may. But the courts have over the years said the issue of whether or not you are going to hear a student or any other aggrieved person is not optional, merely because you have used the word may. May cannot take away the fact that in Kenya, natural justice is mandatory. So that what are we saying? Unless this court can say natural justice does not apply to the impeachment of the deputy president, number one, or number two, is also prepared to say investigations were not necessary, then it is not possible to read the constitutions to say that the usage of the word may meant that it is not mandatory. If we apply our value system and the principles of our constitutions, investigations are mandatory. You cannot pass a verdict minus that investigation. Apart from the issue of the doctrine of separation of powers that we talked about it, that parliaments, but I'll come to that question, which Genda made some good submissions. It's one of the issues we are picking up.
You're admitting.
No, just relax. My Lord, I start with Professor Gebu, I believe is the one who spoke first, senior counsel. Professor Gebu Muigai said that contrary to what we had submitted, that the Constitution makes provision for the procedure of impeachment of the Deputy President. And I wish to reiterate that it does not. Article 105 of the Constitution says the issue of impeachment of the President. Article 150 requires that you modify the procedure in 145 in order that it can apply to the Deputy President. What does this require in actual terms? I believe I asked Sylvia, what does, because Professor Muigai kept on talking about mutatis mutandis. So what does this mutatis mutandis mean in plain English? In plain English it means the original exists, which is 145. Then you need to get, what is it, the generic. That's what they say. You need to get a generic. The generic in the medical world must actually exist. The generic and the original are basically the same medicine except certain ingredients. So, so there must be in existence a document.
That's not correct scientifically, but it doesn't matter.
Okay, I refer to the science. But my understanding of generic, I have a good pharmacist, is that a generic is based largely on whatever was the original drug that is supposed now is generated. Now, be that as it may, in the simpler language then, what it would mean in my understanding is that if you say you have procedure A, 145 for the president, you must be able, when you are impeaching the deputy president, on account of Article 150 to say, in obedience to the Constitution, the National Assembly and the Senate modified it this way. Because the Constitution does not say it will be done through a legislation, it means it can only be done by standing orders. Because those are the two instruments, legal instruments that can be used by Parliament to do anything ordered by the Constitution, legislation or standing orders. My Lord, there are no standing orders that have been waived that demonstrate that a procedure was made pursuant to Article 152 of the Constitution. If that be the case, then there is non-compliance with the Constitution, what it says expressly. We needed something to be waived. But it is obvious that they could not be able to undertake this impeachment without somehow creating some procedure. And they actually did that. And it was annexed to the affidavits of the Senate, or the National Assembly. Annexed, I believe, number 2, did they call it part 2 of an annexed bundle? Bundle number 2. It's a big bundle. I couldn't carry it here. Page 1296 and 1290. No, 12. No, it was 1277. 1277. What did the Parliament, the Senate do? They came somewhat with a program, like those things we have for weddings, saying Gachagua will get 2 hours, National Assembly will be able to get this. And you look at it, my lords, and you ask yourself, this cannot possibly be what modification could have meant when the Constitution says. We don't know who made that program, that they say this program is the one we are going to use to impeach the Deputy President. So that, my Lord, in evidential terms, there is not before you a modification that has been availed by the National Assembly or the Senate. And this explains the reason why, in America, Chief Justice Rehnquist, he has the trial of Bill Clinton for an entire month. But here, because you've come up with some kind of a burial program that ordinarily takes a day, that's how you want to impeach or conduct the trial of a deputy president. But this would subject us to be a mockery amongst nations that are proud to be constitutional democracies. So I agree with my learned friend, Professor Ogada, that there are certain things, and the other gentleman who spoke, there are certain things that are simply not permissible in a constitutional democracy. And one of the most fundamental one is this one. But the next issue is the issue of timelines.
While we are still there,
Yes.
how would you, for example, if the impeachment proceedings are
Yes.
to be modified
Yes.
or with necessary moderation,
Yes.
and because if you fail to modify, that is also the alternative, that we don't want any moderation. Is that also correct? That there may be no need for moderation.
There is no, when you look at the previous submissions,
Yes.
I didn't want to touch that because I would raise 1,000 objections.
Yeah.
But when you look at our submissions, we actually explained, my Lord, because all those things I believe Mr. Martin Kamaro dealt with it. You can charge the Deputy President for all these statutory offenses.
No, what I'm saying is this.
Yes, if you don't modify.
Yeah, if you don't modify, is it also an option?
It's not an option.
It's not an option.
Yes. The reason why it's not an option, I'm saying, we explained that the Deputy President is not a Commander-in-Chief. The Deputy President does not enjoy any immunity. We explained all those reasons. So you modify So that whereas you can say, if the president engages in incitement, and I think he does all the time, you need to impeach him. But if the deputy president engages in incitement or hatred, there is a national cohesion and a penal code that you can resort to. So the modification allows you to be able to factor into the fact that ordinary criminal offenses, and I believe we said a lot on that, cannot be the basis for the impeachment of a deputy president. But serious theft and corruption can be used against a sitting president for the simple reason that in the meantime, he cannot be taken to court one. And since that might threaten the state, that is why impeachment law is there. So that is the logic and the constitutional theory behind it. So it is a must that you must modify. Because this is not the same office. They do not enjoy the same status. When I'll be talking about the constitutional crisis, which is an important thing according to the first petitioner, you have
already clarified that.
Yes, my Lord. So to go now to the issue of timelines. My Lord, these timelines are important.
Point though, to which we did not address ourselves.
That was for our benefit. It was not for your benefit. And he has clarified.
Yes, but my Lord, the constitutional threshold, the differential that he's submitting with them falls squarely onto Article 27, that is asking for differential treatment for a DP who is elected on the same ticket as the president.
My Lord, I believe in Article 50 of the Constitution. If after I'm done with my submissions, the rest of them believe there is anything extra they might say, I will not object. So let us have a flow of my submissions. I would never object. And I didn't object when you were talking.
No, it can't be like that.
Yes, my Lord.
It can't be like that, that after you finish they come back. They can't come back.
I understand.
You can just give them a latitude to comment, but they can't come back.
Okay.
Yes.
But my Lord, we talked about differential. The differential treatment, the actual modification seeks to achieve differential treatment. That is a direct answer. That one of the person is a president. He appoints everybody, including the people that he appointed that are causing the impeachment of the first petitioner. He appoints cabinet secretaries that have appointed the other people that the deputy president was being accused of. So that's a differential treatment. And therefore, they are not treated as the same. It is a reason for the modification.
So this modification actually is a command?
It's a command, my Lord.
According to you?
It is, not according to my interpretation.
No, according to your submission.
Yes, our submission.
It's a command, of the Constitution.
Yes, and we have explained the basis of it, the legal basis of it. It is explained in detail, both in our submissions, actual pleadings, and in our main submissions that we submit.
Okay, now proceed.
Yes, my Lord. Now, to proceed on that other issue, the issue of timelines is a cross-cutting issue, so I don't need to mention any specific person. But the issue of timelines, and I like to follow 258, why does the constitutions of Kenya, and even in articles of impeachment you will see, sometimes how do we deal, the Supreme Court deals with the elections of the president? They give timelines. Elections, petitions, they give timelines. Impeachment, in some instances, they have given timelines. Some instances, they have not. What is the reason for it? Part of the reasons are historical. I'll not go into that. Part of the reasons are technical. And in order to achieve certain other values of the Constitution. So that, my Lord, when you look, for example, at how Parliament is going to do its job, Parliament was given latitude through standing orders to ensure, and there is a provision where they say hearing is part of the conduct of Parliament, natural justice, to ensure that you come with your own timelines in order that, in accordance with the Constitution, you can impeach. In the Senate, which is where now the elaborate position is given, the Senate, they gave the 10 days for the committee to carry out the investigations. But my lord, you will notice that the trial, after the Senate receives the committee of the Senate, of the Senate's committee, there is no timelines that is given. Why is that the case? It is the case, my lord, because you cannot be able to prescribe how a hearing will take place. People get sick, like it was in this particular instance. You cannot be able to tell all that. If it is the US, the Chief Justice is supposed to preside, the Chief Justice may not be able to be available, and he might even himself become sick. Even here, for good reasons, we have failed to proceed in the matters in the past. So that, my lord, the whole argument why there is actually no timelines is because you are sitting as a court, albeit a political court. And a court has a duty, pursuant to the adversary system, to ensure the people you want to impeach, you have actually given them the latitude that is required and to decide how they are going to defend themselves. But you cannot have a situations whereby, with like a one piece of paper that looks like a funeral program, you are telling the deputy president that defend yourself in 2 hours, you are telling Parliament, adduce your evidence in this. My lord, that is not the way it's supposed to be. So that, my lord, the point I am making is that in this particular instance, when Senate decides to impose timelines through that program, which is not in accordance with the Constitution that has prescribed timelines, that is outside the Constitution. And that is why the first petitioner is entitled, and his supporters that I represent, to say, fair trial was not possible. Fair trial for 11 charges, before some of them were dropped, is not possible in 2 hours, even chicken leaves. Nobody has ever done the trial of a chicken leaf in 2 hours. So that's a major consideration. And that's why I'm saying that the question why timelines are there or not there, because in this case, they were not there. My lord, we go to the issue of the appointment of the deputy. President has 10 days. He decides he has 2 hours. In fact, the process starts before the impeachment vote has taken place. Why do you have the 10 days? You have the 10 days because in a democracy, you give people that have floated these names. You give people an opportunity to be able to say, is this a good person, is he effective, all these kind of things. You have 10 days. When you reduce it into hours, it means that the impeachment and the replacement is one transaction. The timelines provided by the Constitution says if there are actually the president has 10 days to carry out transaction 1. Then after that 10 days, you have 60 days to process the issue of the person who will assume this important office. So that, my lord, you now see what we are dealing with. This parliament, 13th parliament, which I say it is a scandal, like the 6th parliament of the 1980s. This parliament, where there are timelines prescribed by the Constitution, they disregard them and do their own things to the prejudice of the Kenyan people. Where there are no timelines, they impose timelines. So that, my lord, when there is a complaint that within the understanding of a constitutional democracy, fair trial could not be possible, it is because there are good reasons that you can read them by a correct reading of our Constitution. I don't want to say anything much about timelines. But therefore, there is a general issue also of the constitutional, of judicial power, the nature of judicial power. There was this argument that it is made in almost all political cases that I am aware of, that the judiciary should be careful, not because it is not elected by anybody, and it should let those people who have been elected to do their job, it is within their discretions, all these kind of things. My lord, I don't want to say much, but I just want to say 2 things. Article 2, is it true yet? Not true. The article that talks about, that refers, Yes, it's actually Article 2, which refers to Article 10. It's true. My lords, Article 2 of the Constitution says how public or state power is to be exercised in Kenya. It talks about, go to Article 10 of the Constitution. That is number one. So that it is legitimate, and it says everybody is under the Constitution, apart from those national values. So that it is mandatory that everybody must act in accordance with the Constitution. Then number two, the Constitution says that the courts are the guardians of the Constitution. What the law means and whether any act is in compliance with the Constitution, it is a decision of the judiciary. And last time I had said, not the entire judiciary, but specifically the High Court under Article 165 to decide whether that issue, whether anything done in accordance with the Constitution is indeed the case. It is in that sense that the High Court is the guardian of the Constitutions, because as I've said, everybody else confirms whether High Court did its job as the guardian of the Constitution. So that, my Lord, in making whatever decisions we will be making, the only way the Constitution of Kenya would be our supreme law and protect everybody, however mighty or law, it is by ensuring that the supremacy is upheld and the Constitution remains supreme law. So that this argument of you are not elected, you are not done, everybody else in job works under the Constitution, but the same Constitution says it has appointed the human hand, namely the judiciary, that confirms whether everybody else has acted in accordance with the Constitution. They can take that away in a referendum, where they can also go and say, like they said in 1982, to say Kenya is a single-party state. Until, so long as there is a provision of the Constitution, Article 4, saying Kenya is a constitutional democracy, they are bound. Judiciary has the final word on this issue. My Lord, I go to the next issue. Then the next issue is, I believe I've dealt with the role of the Senate. It was a cross-cutting issue. And the important thing that I think I just needed to say about that would be three things that are cross-cutting. Number one, the role of the Senate, it first of all comes from Article 96 of the Constitution. And it is to check, when they carry out impeachment trial, it is to check abuse of executive power. That is actually the main thing, abuse of executive power or any other power that may be arise. So that, my Lord, in checking now that power of the Senate, necessarily the Senate must be taken into consideration whether the charges that are before it manifest abuse of executive power, because that's the main responsibility. So that, my Lord, when you have an official, because the Deputy President, under our constitutions, may be a very important person, except one thing. The Deputy President does not exercise any executive power granted directly to him by the Constitution or any statute. It is important to bear that in mind, because if you don't get that in mind, you might lose a lot. My Lord, the second issue is that I have talked about the mandate of parliaments, where we are saying Senate was not told that you have discretions to impose your own timelines. And of course, we are talking about the issue of the Senate. And I believe my learned colleague, Ojienda, Honorable Ojienda, this is where we come in, Senior Counsel. My Lord, I agree with what Professor Ojienda said, that when the Senate is performing its function under Article 145, the Senate is really a jury. It's a jury system. You are, the function, even with this calendar that they gave, this little program they gave, it's actually said National Assembly. Yes, whatever it is. It's like a program, everybody can see it. But it's a one-page program. My Lord, that one actually said the National Assembly would prosecute their case, and the defense would have their bit. So that for purposes of a regular criminal trial, we know that it was supposed to be there's some prosecutor, there's going to be some defense. And the Senate were to vote. Ojeda, professor, said, we were, what did you say, 67? We were 67 judges. We were 67 jurors. That's actually the case. Because that is the way it is envisaged to be. But now, the moment that concession is made, that you listen to argument, the way the judges are doing, you will have your issue in your judgment. You will deliver the verdict. So it cannot be the duty of a judge like it is, like to say, to advance any position. You hear the positions that are being presented, then you make a verdict. It is the same case that was supposed to happen at the Senate. And as Professor Ojeda said, they are jurors. So that, my Lord, I am saying that in order to point out a contradiction. When now in the other submissions they are saying that they could discharge the role that the Constitution says belongs to the special committee investigation and to decide whether any charges have been, what they use is called, substantiated. The jurors cannot play such a role. They pass the verdict. And that is what points out as that contradiction. That you cannot on one hand say we were passing the verdict, we were jurors, but on the other hand we were the investigators. The DCs, Gibson Kamaukuya told me to come and say that, the DCs of colonial Kenya used to exercise powers of prosecution, investigation, and all these. But that's why we made the independent constitution and now the 2010 constitution. In all those constitutions, my lords, and we have the judgment of Judge Mrima in the Kinoti case, you cannot have a fusion of those powers and to be exercised by the person passing the verdict. So it is necessary to understand that there is a good constitutional reason why the argument that they were making is completely defective and can easily spoil the good reputation of the Kenyan judiciary if they were to miss such a basic point. And that is why it is important, as I say, that needs to be understood. There is a history behind it. We used to do it in colonial Kenya. It cannot be introduced by the Senate of the 13th Parliament, bad as it might be in my view. It cannot introduce colonialism in Kenya. But now we go to the next issue, my learned colleague, Mr. Mushemi. I only raise one issue. He said many things, but there is no time. But one issue that he said is that when Mutuse does not belong, Honorable Mutuse does not belong to UDA. He belongs to that party of Chap. That, he said, like, by the time when you were doing this, it was obvious to the entire country that the Deputy President had lost the confidence of his own party, UDA. And that is significant because the case I was told to come and advance here is that this was a political conspiracy, a political witch hunt. So that in a genuine matter where you are acting in good conscience, violations of the Constitution, it cannot be preceded by saying that politically, that was the understanding. This man must be removed. Because impeachment came to replace a vote of no confidence. Confidence is purely political. You actually don't need to give any reason. You can even say Kalonzo takes a lot of time to comb his hair, and we don't want this, and you get him out of office. Well, that is enough in a parliamentary democracy. But if Kalonzo combs his hair too many times, he cannot be impeached. And I believe that's the law of Kenya to distinguish between the two. Here now you had the lawyer for Honorable Mutuse saying that he had lost the confidence of UDA. It confirms the basis of the case that we are propounding. We go to the next issue, Mr. Kamogo. It's called Adrian Kamogo. I don't know whether he's there today. My Lord, you will remember Adrian Kamogo, when we started these proceedings, he was appearing for both UDA and the sixth respondent, His Excellency, the President of Kenya. At some stage, he exited and said, I will only appear for UDA. The consequence is all those things that we have said about the political conspiracy have not been answered. Going by the decision of the Supreme Court saying, in other cases, if the AG should answer for the president, I didn't hear the AG answering for the president when we say this charge, number one, of tribal appointments and regional balance, these are things that were done by the president under the law and the people that he has appointed. That is not controverted. So that contrary to the Senate could proceed to indict and impeach somebody and remove them from office without any evidence. It is our submission that before the High Court of Kenya, where somebody says, it is not me, they must give evidence to contradict that. And so, if certain communities have a bigger number in public appointments than others, who is responsible for that? That is not a question that can be avoided by the High Court. It was avoided at the Senate. But the Senate is political, and you can excuse many of them for very many things under the sun. Now, there is the issue of the South, yes, I already did with the South African judgment. But I have given you the court clerks, the submissions that we did. I don't know whether they still keep. I've even given them this. I gave you this and this to make it easy. We produced the judgment in a bound form like this, and we had also given some submissions because we were suspecting that we may not have sufficient time to deal with it. But my Lord, I need just to take 5 minutes. We have supplementary submissions. Everybody was served with them. They are dated 12th of May 2026. Where I only want to say 3 things. But before I say those 3 things, let me say this. That when we made our constitution, the South African constitution was in existence. And we borrowed quite a lot from South African constitution. But when, my lords, my lady, the South African constitution, when you read it, the substantive provisions on impeachment, they are more or less like the American constitution. There is no, unlike Article 145, they do not have an equivalent, where they set out a procedure on how to go about it. There are a number of cases. We are being told case number 1, 2, and 3 about how that subject has troubled South Africans, how to deal with the issue. The long and short of it is that on account of the intervention of the Constitutional Court of South Africa, the South African Parliament made rules that by and large mimics Article 145 of our Constitution to govern the impeachment of the President. That's a broad issue. Now, in interpreting that particular issue in the decision that is before the court, what the South African court said is that where there was provision that investigation were to be conducted upon a committee, some probe committee, finding that it was the current president, Ramaphosa, because he was even being told to resign on account of that decision. They said that the impeachment committee is a mandatory provision. The judgment explains that issue at length. Because it is because what the South African committee, when they voted not to have the committee, the South African court was saying Parliament does not have power to shield the president from unnecessary constitutional investigation in order that a vote may be carried out. So that they purported to give themselves a discretion that the South African court said, you do not have such discretion. Your work is on merit. You must decide, and after all procedures have been undertaken, you must decide whether the president committed the offense or not. That in plain English. The issues can be stated in a more difficult way for non-lawyers, but that's the main issue that was there. So, for purposes of the highlight that we want to make, is that in the same way, if the South African text, courtesy of the South African Constitutional Court, has shepherded the making of rules that mimics our Constitution, it is this rare moment.
My Lord and my Lady, I think we have to object because counsel has a duty of candor, and since we won't have a right to address you further, he cannot tell you things that are not accurate. He's telling you the South African Parliament has made rules that are similar to our Article 145. That's not factual. That's misleading. Number two, even on the judgment he's referring, that judgment is just about one rule out of about 8 to 10 rules. That judgment does not tell us what those other rules are so that the conclusion can be made. They are similar to our Article 145. They are not reproduced anyway in that judgment. He has not himself reproduced them so that he can lay a basis for telling you that they mimic our Article 145. The undeniable fact is that they are different from our Article 145 as part of duty that is different from ours. Thank you, my Lord.
Well, the direct answer to that is this. When, after this South African judgment was delivered, we proactively did these submissions. And what we are highlighting these submissions. I remember the court directing everybody else has a right to do additional submissions on the South African judgment. But even before writing, they actually talked a lot about the understanding. Was it my friend, Mr. Kipogei? It is Mr. Kipogei. He said what he understands the judgment to be. So that, my Lord, I say it is the court to decide whether I'm wrong or I'm right. And in these submissions, which is what I'm highlighting, the court can be able...
Mr. Kibe is not responding to my objection. My objection is this. He told you not once, but 3 times, that the rules for impeachment in South Africa are textually similar to our Article 145. It is our case that they are not, and I'm saying since he's replying, he's an officer of this court as an advocate. He cannot make claims that he knows or ought to know are factually inaccurate and then proceed, especially when we won't have an opportunity to respond to it.
I think we have found a way of dealing with those kinds of claims because we have noted that parties only highlight sections of rulings or judgments which support their case. And when you go back to the text, you find that there could be an element of parties trying to mislead the court. So I think every party is entitled to interpret a judicial text the way they want. It's upon the court to determine the weight to give to that interpretation.
Thank you. And I don't mind to be told I'm wrong on that. I was about to say I should be allowed to do an affidavit to provide the rules, but it is not necessary. So that, my Lord, and now I'm forgetting even a few things. I don't know whether that was intentional. But on the point I was saying about now my understanding, the South African, they imported something from Kenya under those rules. Because their constitution does not talk about this special committee. The special committee actually exists from some rules that exist in South Africa. Now, because of that, and they say those investigations are mandatory to be carried out. And there is no discretion for Parliament. That is the most important issue. So that, my Lord, in the same way, and that is the relevance of this particular decision, that in the same way that times without numbers, we have decisions of the Kenyan judiciary talking about how the South African constitution have had good provisions, like in public participations, and how they have been interpreted. It's also a good moment for Kenyan to, through the judgment of this court, for the Kenyan High Court also to let our constitution shine and draw out to the entire world of democracies that in Kenya, when the makers of our constitution were doing the job for avoidance of doubt, there was a clear procedure that makes this issue not optional. So that in short, the problems, and you've seen is a problem that has taken like 10 to 15 years in South Africa. The problem on how to impeach the president or the deputy president. In Kenya, it is clearly set out, provided that the constitution is complied with. If the constitution says 10 days by a committee, it's 10 days. So, my lord, that's a golden moment that I have to remind the High Court that we also need now to say we've got a good constitution, it does this. Point number 2 on that issue is this, that you can imagine, my lord, a situation whereby in South Africa, after courtesy of their constitutional court, they have made rules mimicking Kenya that establishes this special committee, and they say it is mandatory. How would it look like if the same Kenyan judiciary, we thought on the face of it looks like a good constitutional provision, read that constitution to remove discretion? Because the Kenyan constitution, properly read, does not give Parliament this discretion. In South Africa, Parliament, because they made the rules, they appear to give themselves discretion. So that, my lord, what I'm saying, because we read the decisions themselves and our submissions, is to ensure that the Constitution is read in the correct manner and in a manner, because this is these kind of judgments that will be read 100 years from now, as long as this Constitution exists. This is a kind of decision that must be done correctly and to run the error, and I've pointed out why in reading Article 145. If one were to read it as suggested by the respondents, we would scandalize the High Court, the Kenyan Judiciary and its profession. Therefore, my lord, I'm urging you, because when the South African case was delivered, it was a day after we have said, we had interpreted Article 145 in the manner that was confirmed the following day by the South African Constitutional Court. So I urge you to read that decision and our submissions and enable you to interpret properly 145. The second issue on that decision, before I go to this constitutional crisis, is this. That what is it that was moving the South African, the underlying factor? The South African Constitutional Court, my lord, was saying that in a democracy, you run the risk of actually subverting democracy itself when a constitution says presidential misconduct, presidential illegalities would be done by the necessary vote of Parliament after an investigation has been carried out. So that they say this cannot be permitted. To permit a rule that Parliament can discharge a constitutional function in a manner that they wish would be an abrogation of democracy. It is the same reasoning, my lords, that I've been trying to persuade you to hold, that an impeachment carried out contrary to the Constitution subverts everything. The democracy itself, it subverts the issue of the purpose that was supposed to be met. The final issue is what the first petition tried to tell me, constitutional crisis. I have read a few books, as I said. Gibson Kamau Kuria was my employer. We ended up, he used to have very many books on this constitutional crisis. I've read a lot in that area, but I don't want to go into all that. But what was a constitutional crisis, strictly understood in simple language? We'll talk about constitutional crisis.
People provide the titles of those books. You can't just say books here.
Get serious. My lord, as I've said, those books are many, as there are many articles written in that issue. It's Mr. Bodomi who said that point that he doesn't want intervention himself. Because he made an important point that made the first petitioner to tell me, Kibe say something about that. This is what I want to say about that. It was a constitutional crisis. Apart from the reading of these books that were talking, Ben Wabueze's many books has written about that. For example, the issue of coup d'etats, the excessive ones. Those are the ones that generate a constitutional crisis in a country, because the country ends up being governed by people who have taken over and with no mandate of the people. And where you cause civil war, you cause instability, and when that instability is traceable to the failure of the constitution, then you say you have a circumstances whereby you have a constitutional crisis. Now, our constitution anticipated the possibility that there might be a disconnect between politics and the constitution and how the system of government that you put. It is why in Article 3, they say, I believe it's 3.2, that any attempt to establish government other than in accordance with the constitution is unlawful. That provisions, my lord, if it has never been read in any other manner, it was put in order to avoid, the mischief here is this, an attempt to establish government other than in accordance with the constitutions end up generating a constitutional issue, a constitutional crisis, and a political disorder. And the immediate context, again, is simple, because it is this, that we say we establish government to run Kenya for 5 years on the basis of a mandate for 5 years granted in the previous election. That government has the purpose of election is to decide which party and which individuals are going to run government. Those who did not, whose parties did not win, and whatever, the constitution, in the current constitution says you will be a minority for purposes of running government. And the mandate to run government is a collective mandate granted in an elections by the people who together, like if it's the presidency, president and deputy, who went to seek for the vote of the people based on this or the other true stories or falsehoods, but they get elected. Now, that having been achieved, it cannot be possible by any single individual or in conspiracy with anybody else midstream to change the composition of government. When you change the composition of government, apart from the fact that you violate Article 3 of the Constitution, you also generate a constitutional crisis. How does it manifest itself? Even in ordinary social media accounts, even in ordinary political speech and newspaper reports. You generate it because, like today, Kenyans keep saying that whatever government says happens in Kenya. And because there is no longer, the divide has been blurred. There is no government, the people to govern government, and people to hold it responsible. And who suffers? It is the people. Because the institutional mechanism to ensure government is politically held responsible is not there. We used to have PAC, the Parliamentary Committee of PAC, and PIC, that the law specifically says these should be held by people who are not in the parties that are running government. Because of the series of events that have happened in Kenya, courtesy of the BBG, that is no longer the case. The government and the same people running these committees, the same people running the minority, are in government. It is a scenario, my lord, what was the cause of all this? The immediate cause of all this was the impeachment of the first petitioner. So that it is important to say that if you are suffering a political problem in Kenya, where government becomes unaccountable and abuse of executive power is the cause, is the thing, is the nature of is the order of the day, this is traceable to the fact that government, in accordance with the Constitution, was suspended with the impeachment of the first petitioner. That's the important point that needs to be understood. that you cannot talk about a constitutional crisis like something up in the sky. You must reduce it to the elements, what it means, and how it manifests itself in any specific country. We are dealing with Kenya at the moment. I will not go to those other issues. But the two and third point now on this constitutional crisis is this. You are told by my learned colleague, Dr. Muthomi, that there is this issue that how can Parliament be faulted for impeaching a deputy president who was talking about issues to do with shareholding and these kind of things. Now, the direct issue, as we have said, is that when you look at the arguments we've made and we are just reiterating, is that he was not accused, because he does not have those powers, of any abuse of discharge of executive function. That you did this, and because you are responsible that 1 or 2 or 3 Kenyan communities are overrepresented in the governance of the country, that there is something wrong. He was accused, because it is important, he was accused. You only talk about either the Kikuyu sometimes, or sometimes Kema, and that polarizes everybody else. Karuti Kaningas, we use the book, and we have cited the actual statistics in the affidavit, that clearly demonstrated, my lords, that if one, and a court of law must care about facts, if one cared about facts, in the current situations since 2022 of public appointments and all these kind of things, the two communities that are actually overrepresented significantly above their population quota are actually the Kalenjin and the Somali. That is what the affidavit says. But more importantly, my lord, it is said in our affidavit, and you have not challenged it. Well, it's for the judge to decide. There is an affidavit that is uncontroverted. But more importantly, my lord, my learned friend, Mr. Kamwaro, I didn't even know about that. But he was saying, he was telling me, you know, Kita, when I read those statistics, what I actually saw is that the Maasai and the Somali are more or less the same number in terms of population. But there are no Maasais. The Maasais are very few. So those are realities, my lord, that anybody who wants to talk about this difficult subject must actually confront with. In fact, he went on and said, I look at the Mijikenda, they seem to be more than Somali. But there are also very few Mijikenda. So that, my lord, this issue, and I talked about being trivialized, this is an actual problem that exists in Kenya. But it cheapens everything. When you say that the first petitioner is responsible for it, because now that for about 2 years he's out, why has it not been rectified? Just the other day, the Public Service Commission confirmed what we say in our affidavits. These are government documents, nothing to do with us. The final point on that issue that...
You remain with 1 minute.
Yes, and just is one point, one small point. That final point, my lord, that you notice, is that for purposes of this constitutional crisis, I have talked about the attempts by in 2013 to ensure President William Ruto and Uhuru Kenyatta did not contest the presidency. We talked about that case, what a 5-judge bench of the High Court decided. The bench basically said, you know, impeachment, that is the political balance going on. You are impeached, you cannot have presidential ambitions. Presidential ambitions are not, it is not a man who decided I want to be president. It's a community or a number of political organized people who say we want you to be our leader. So then, my lord, and that was the basis for which they say Article 38 does not just concern the right of an individual to seek political office. It is also protects the political right of his supporters to be able to to ensure that you participate in elections. My Lord, constitutional crisis, we had it in Nigeria. I have 1 minute, so I don't want to take it time. Where they wanted to stop their deputy president from somehow succeeding, interfere with political succession. Actually, interference with political succession is one of the major reasons when you read many of the books, why they generate political crisis. My Lord, anybody who lives in Kenya knows that since the impeachment of this unelected deputy president, Kenya cannot be described as a very, very stable place. The politics are in a serious state of confusion every day. I am finishing.
There's no constitutional crisis. And Kenya is not an unstable country.
He talked about constitutional crisis, not me. Let me finish. You will say that in a political speech if you can permit. My Lord, Mr. Mudomi, I'm just responding. Mudomi introduced the issue of political constitutional crisis, not me. I'm just trying to say political crisis results into political instability. But the ultimate political instability that can occur in a country is to, on account of a politically motivated impeachment, to get yourself in such a scenario that you say the leader of an important political constituency comprising probably 25 to 40% of the Kenyan population is going to be excluded by a defective impeachment from realizing the political aspiration. It is called, in the normal electoral language, disenfranchisement. Disenfranchisement of a political community or a political party like we had to deal with the GNA in 2013. My Lord, I urge you that when you consider all that it takes on the issue of what is and what is not a political crisis, the impeachment, there can be no judgment of this court that would cause a constitutional crisis. If the judgment voids the impeachment that took place, only a simple thing would happen. We go to the status quo ante. At that particular time, I believe it's politically untenable, as it seems to be saying, for the first petitioner to say, I want to remain a deputy president. But what it means in practical terms, because it is important that this is said by a constitutional lawyer, it simply means the problem, the issue that was aborted about the proper appointment, the 10 days period, and the 60 days period would have to be repeated so that legitimately and unlawfully we can get a deputy president under our constitution. That is assuming if the first petitioners, this petition succeed, still commits that he doesn't want the job. This court cannot cause a constitutional crisis by upholding the constitutions of Kenya. My Lord, I thank you for the time that you have given the clients I represent and many Kenyans of goodwill who have called me with all kinds of suggestions to make this submission. I thank you very much.
Thank you. Njero Ndegwa, with those submissions, we can give you 15 minutes.
My Lord, I try to think the circumstances. I don't think that I represent similar clients like those of Kibe. My Lord, permit me to begin by saying that again, the court is being, or rather all the submissions that have been made before this court, my Lord, have the intention, and then most especially from the petitioners, to preserve our constitutional democracy. The petitions that have been placed before you, my lords, they are all challenging the process within which the first petitioner was impeached. I associate myself with the submissions made by my colleagues and add that, my lord, that today, or when this court will be rising up to pronounce itself, it may find itself in the same situation again where Fidel Castro was on the 26th of July 1953, when he made his speech that history will absolve him. Small synopsis is that he had just made some attempts to overthrow Batista, and he was acting towards the revolution of the people, and the statement that was made was to encourage the people that the revolution shall not be lost by his trial. We hope that the constitution of this country and the people's power conferred by Article 1 shall be preserved by the judgment of this court. My Lord, permit me to begin by reacting to the submissions by my learned friend, Dr. Dion, where he invites you, my Lord, to look at the alleged election of the current Deputy President as a constitutional process, Mr. Kindiki. My Lord, submissions were made, and most importantly again by Mr. Noor for the IBC, that the whole process was in conformity with the Constitution. There is nothing that can be further from the truth, my Lord. Mr. Kindiki's process was fraud, unconstitutional, unlawful, and the same is completely a stranger to our Constitution. You are told that it was not mandatory for us to have the commission in office for the commission to oversee the process of this election. My Lord, Article 149 has two very key overriding terminologies. One is that Mr. William Ruto was to nominate. That is, the president shall nominate a person to fill the vacancy. Number two, the National Assembly shall vote. Two very key words, nominate and vote. This cannot be said to be anything that Parliament was being invited to approve. Parliament was being invited to exercise the people's power under Article 1 of the Constitution through the delegated democracy process. Of course, the drafters of this Constitution, my Lord, were alive to the fact that it would not be possible for us to go and replace the Deputy President through the universal suffrage. That is why they delegated this function to Parliament. So anything that, any process that is initiated or commenced by Parliament and by the President in their attempts to replace this office, this vacancy, must resemble the process in which that person who was removed came into that particular office. That is to say, Your Lordship, if you are to look at Article 148, it says that each candidate in a presidential election shall nominate a person who is qualified for nomination, for election as a president, as a candidate for the deputy president. Again, the candidate for the president is being granted the mandate to nominate. Then you are told that at 148, clause 3, the Independent Electoral Boundary Commission shall declare the candidate nominated by the president who is elected as president. So we can see the involvement of the IEBC during the direct exercise of the universal suffrage in the exercise of coming up with the nominee of the deputy president. It cannot be therefore said that when we are replacing that particular person who came into office through the universal suffrage and through the process of nomination, that he ought not to meet the qualifications under Article 137 of the Constitution. And who is mandated to make sure that the provisions of Article 137, the qualification and disqualification, are met if it is not the IBC? There is no process, there is no provision in this Constitution that mandates the Secretariat to execute the functions of the Commission. The functions of the commissions are strictly confined to be executed by the Commission. The argument, therefore, that when Mr. William Ruto wrote to the IBC, he was only seeking for information, we must then ask ourselves, what was the purpose of that information? If the purpose was not meant to replace an office, to replace a vacancy. He was not acting under Article 35 of the Constitution, where you're simply saying, I want this information to confirm whether Mr. Kindiki was a registered voter. He was asking for that information for purposes of replacement. And therefore, my lords, this replacement must meet the test under Article 137 of the Constitution. The functions or the qualifications under Article 137 can only be met by a fully and well duly constituted commission. To the extent, therefore, that this process was initiated in the absence of the commission, and when the commission was not duly constituted, this process was a constitutional fraud. There was no one to decide whether or not Mr. Kindiki had met the qualifications designed under Article 137 of the Constitution. And if you want to know that the Commission must be involved in this process, look at its functions, the function the Commission is playing under Article 148. Your Lordship, I go to the next point. That, my Lord, you need to visit and look at the IBC Act, and most importantly, I'll just mention them. You look at Section 5 of the IBC Act, which defines the Commission. Look at Section 4, again, of the IBC Act, which defines the functions of that Commission. Again, Section 10, subsection 6 of the IBC Act, which creates the Secretariat. And it provides that the Secretariat shall perform its duties and shall be responsible and answerable to the Commission. So even this particular time when they are deciding whether or not Mr. Kindiki is qualified, the Secretariat is answerable to the Commission, and the Secretariat is responsible, is answerable to the Commission, and the Commission is responsible. Number 2, Your Lordship, Section 10, subsection 7, paragraph E, Roman 1, again provides that the Secretariat shall execute their functions, or shall execute the decision of the Commission. The Secretariat is ideally a conveyor belt of the decision of the Commission. So where was the Commission at this particular time, and whose decision, when the Marjan in the conspiracy wrote to Parliament to confirm the qualification of Mr. Kindiki under Article 137? Where was the Commission? Where was the Commission again at night? Mr. Marjan, he cannot replace the Commission. If the people of Kenya, by Parliament, wanted Marjan to execute his functions, they would have expressly said so. My Lord, if you are therefore to confirm that process as a process that conforms to the Constitution and the statute, we shall get to where my learned friend C. and Hibe was submitting, the constitutional crisis. You shall have affirmed a person to hold office fraudulently. That person, to the extent that he was nominated and purportedly voted by Parliament in contravention of the Constitution, Your Lordship, it therefore invites you to look at the import of Article 3. Nobody shall be allowed to form government as, may I read it for purpose of clarity? Any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. So even where we are, my lords, to the extent that our submissions confirms that Mr. Kindiki was unlawfully put in office, we are already in that particular constitutional crisis. A government has been formed unlawfully. And the only person who can rescue us from this particular process is this court. My Lord, permit me to state that constitutional offices, and most importantly, the office of the President, represents the people of Kenya. And therefore, Your Lordship, if the people of Kenya are to be represented in that particular process when Parliament was voting. Your Lordship, that process of the voting did not derogate the peoples of Kenya's their ability conferred, one, under Article 1, number 2, Article 10, number 3, Article 118. Submissions were made that public participation was not necessary when replacing this office. Then what were the 60 days for? Why did we Kenyans decide that we have 60 days within which to fill this vacancy? The purpose of these 60 days, Your Lordship, is to make sure that the people of Kenya are fully involved. The vacancy that was created, unlawfully created, did not belong to the President. It did not belong to Parliament. It concerns the people of Kenya. To the extent, therefore, Your Lordship, that public participation was not initiated in this process, and noting that Article 118, Clause 2, provides that when Parliament initiates any other business, they shall call for public participation, Your Lordship. Then again, there was serious non-compliance with the Constitution, and a government has been constituted in non-compliance with the Constitution, and hence the constitutional crisis. Your Lordship, I know that the Black Law Dictionary will bail me out on the definition of the term vote. The term vote is not the same as approval. While the Constitution wanted the Parliament to approve, it expressly said so. This time the Constitution spoke about voting. This voting, Your Lordship, has a meaning that is the only way the people of Kenya can be involved in the replacement of the vacancy that has occurred. And therefore this vote is similar to the vote that took place on the 9th of August 2022 when His Excellency Rigathi Gachagua was elected. There cannot be any other way that a replacement can be done at night, approvals can be done at night, and then the people of Kenya are told that Parliament has voted on their behalf. That's a fraud. Your Lordship, permit me to state that on the issue of the impeachment, Malane Senior, the Senator for Kisumu, Professor Ojienda, submitted on the gazettement of the impeachment. That gazette, Your Lordship, is a gazette dated 9th of October. If you look at the wording of that particular gazette, it says, pursuant to Article 145, Clause 3, Paragraph A. That is to say, of the Constitution and Standing Order number 78, Sub-Order 1. That is to say that the Deputy President's impeachment was commenced pursuant to Article 145, Clause 3, Paragraph A of the Constitution. I dare submit, Your Lordship, that there is, though the office of the Deputy President and the Presidents are derivative, they are distinct in their functions, and that, Your Lordship, that distinction is what invited the people of Kenya to enact Article 150 of the Constitution, so that there can be clear distinction in the manner in which these offices are managed. Your Lordship, the removal of a Deputy President is provided for under Article 150 and not Article 145. So this Gazette notice commenced the process of removal of a Deputy President as though they were impeaching a President. That is a fundamental constitutional error. It's an error because, Your Lordship, the people of Kenya were not daft that they deemed it fit to enact Article 150. And of course, Your Lordship, the reason why this gazettement or this impeachment was commenced under Article 145 is because they wanted to run away from the import of Article 150, Clause 2, which required Parliament and the Senate to modify this process. This modification, Your Lordship, has been submitted before. I actually submitted at length on it. but just suffice to say that this was not a discretional question. Neither the Parliament nor the Senate could avoid the modification requirement. It was mandatory. And that is why, Your Lordship, the Constitution deliberately uses the word shall. With the necessary, it says, the provision of Article 144 and Article 145 relating to the removal of the Deputy President shall apply, comma, with the necessary modifications to the removal of the Deputy President. This modification, this application of Article 144 and Article 145 had to suffer modification. The person who was to modify was Parliament. Parliament as defined under Article 93 of the Constitution. We could not avoid and or evade that duty. To the extent, therefore, that the commencement of the impeachment process was initiated by the Senate pursuant to the wrong article of the Constitution, Your Lordship, then this cannot be said that's an impeachment that can stand. They were so much in a haste that anything that was supposed to go wrong went wrong. Who should benefit with these transgressions? Should the Senate, should the person who was in pursuit of His Excellency Rigathi Gachagua benefit? Should it be Mr. Kindiki? It is the people of Kenya who should benefit from the provisions of this Constitution by upholding it. Your Lordship, you are told that His Excellency Rigathi Gachagua had filed affidavits and responses. And therefore, there was no necessity for him to appear and defend himself. Suffice to note, Your Lordship, once more, that His Excellency Rigathi Gachagua was the only witness that the defense was to mount for his case. Your Lordship, this was not a trial by way of affidavits. It was a viva voce process. And this viva voce, Your Lordship, again you'll find it under Standing Order 78. When you go to Standing Order 78, you are 78.6, it speaks about the President. It says, where the President chooses to appear before the Senate, let me go to B. It's just about appearance. So it says how the President proposes to appear before the Senate, whether in person, by advocate, or in person and by advocates. His Excellency Rigathi Gachagua chose to appear in person and by advocates. He was to appear in person, Your Lordship, because it was necessary for him to conform with the provisions of, again, of Order 78:11. That he was to appear and go through the process and the entire motion of the hearing. If you, again, you look at, against the same order, number 21, it says, after the evidence on the part of the National Assembly has been presented, the evidence on the part of the President shall similarly be presented. I am reading President because, Your Lordship, there was no modification of these standing orders. That is why I am reading President as it is, and deliberately refusing to replace the term President with the Deputy President because there was no modification. So these standing orders presuppose a situation whereby the person appearing is granted an opportunity to urge his case. That is why, Your Lordship, Order 22 says, a witness presented shall be led in evidence, cross-examined, and where necessary, and only for purposes of clarification of issues that may have arisen from cross-examination, be re-examined. It tells you, Your Lordship, this was to be a full trial. That is therefore, Your Lordship, to say that all the evidence that had been filed by the first petitioner were not to be adopted as evidence or as his full response to the trial. It was necessary for him to be granted an opportunity to be heard. And even, Your Lordship, when the Senate realized of this, they never modified this to say, okay, we can exempt, we can exempt his appearance. You will not find that anywhere in the Hansons. Again, to the extent, therefore, Your Lordship, that this was not followed. Senate itself violated its own rules. If this process was premised on fraud, how can it stand? Your Lordship, permit me to state that affidavits and the responses that had been filed could not have been taken to amount as a full response for His Excellency Rigathi Gachagua. There was need for the Senate to hear him. Why do I say so, Your Lordship? Because before the Senate decides to impeach or not, there is a duty to find out whether the charges have been substantiated. Substantiating of charges, my lordship, my lord, my lady, I understand it to mean that all parties have brought their evidence, the Senate had the opportunity to evaluate that evidence, and then they have, on balance of probability, they know which side the scale tilts to. If the Deputy President was never granted that opportunity, can those charges be said to have been substantiated? Substantiating of these charges meant that one, Rigathi Gachagua, was to lose his seat. But remember, Your Lordship, the process of losing this seat must be a constitutional process. If, Your Lordship, there was no substantiation of these charges, how did the Senate arrive at voting, even for those charges that they upheld? One-sided process. Can it stand in law? We'll be making a mockery of our Constitution if you were to say that the impeachment ought to stand. We'll be a laughing stock of this continent and those other countries that are striving to achieve the steps that we have democratically achieved. That is why it is important, Your Lordship, to follow what my learned friend Mr. Kibe has indicated, that you have a monumental opportunity to speak even better than the South Africans. Because the South Africans' case did not get where we are. I would love to hear that the people in Uganda, people in Canada, people in Australia are quoting a judgment that was presided over by none other but Justice Evans, by Justice Moreno, and Justice Moran.
There's no Evans on this panel.
Your Lordship.
There's no Evans on this panel.
Sorry, Eric, sorry. I beg your pardon, Justice Eric. Thank you, Your Lordship. So, my Lord Justice Eric, I would love to see your judgment be quoted all over this world. What a good day for you. What a good day for the country. What even a good day, perhaps, for your grandchildren. What a good day, my lady. What a good day. My Lord, permit me, as I sum up, to refer you to just one more issue about Mr. Mukele's submission. Mr. Mukele's submissions was that the whole process, despite the pronouncement by the Wambora's case, that we are not engaged in a quasi-judicial process. He even tried to say that when we submitted that Senate was sitting as a tribunal, that Senate was not sitting as a tribunal. Your Lordship, when my learned friend, Professor Ojeda, was submitting, he kept on referring to the Senate as a court. So, Your Lordship, the question of whether or not the Senate was sitting as a tribunal or a court or not, it was sitting as a quasi-judicial body, and it was mandated to ensure that all processes that concern itself with the fair trial were observed. And perhaps it's important to note that Mr. Mukele and my learned friend, Professor Ojenda, admitted the non-existence of a statute or standing orders guiding the process of impeachment. Coming back, Your Lordship, to my final submission, whether or not this court can look into the works of the Senate, review it, and arrive at a decision, Your Lordship, it's my humble submission, Your Lordship, that your hands are not tied. They're not tied, Your Lordship, because at 165, clause 3, paragraph D, Roman 2, confers you with the power to interrogate whether anything said to be done has been done in accordance to this constitution. This thing includes the admissibility of evidence. It includes the relevance of this evidence. You are not stopped from confirming whether the Evidence Act was applied. You are not stopped from interrogating whether there was relevance in the materials that were brought before the Senate. The question whether anything said to be done under the authority of the Constitution or any other law is inconsistent. If you find that the threshold of the evidence that was brought was not sufficient to impeach, then you must find it so. Your Lordship, again, Article 165, Clause 6, again you are told that you also have the power, the supervisory jurisdiction power. The High Court has supervisory jurisdiction over the subordinate courts and over any person, body, or authority exercising judicial or quasi-judicial functions. You still have the power to supervise the Senate. The Senate's functions falls under your supervisory jurisdiction pursuant to this provision. When you're interrogating this, Your Lordship, you are not even barred to confirm whether or not what the members of the Senate contributed spoke to the motion. You are not barred from interrogating whether there was nexus between what they submitted in their effort to find that the motion was substantiated or not. Relevance, admissibility. Your Lordship, finally permit me just to draw your attentions to the state South African judgment. I'll refer you to I'll just quote the paragraphs and the page. Paragraph 38 of the state judgment at page 20. Paragraph 63 at page 30. Again, this is quite interesting. When you want to interrogate where this investigation was supposed to take place. Was it to take place at the plenary? And if the Senate opted for the plenary, did they investigate? What is the nature of this investigation that the Senate was supposed to initiate? Who was to investigate? Again, Your Lordship, look at paragraph 64, at paragraph 31. It says, the failure by the National Assembly to make rules regulating the removal of the President in terms of Section 89 of the South African Constitution constitutes a violation of this section and its validity. The failure to make rules under Article 150 of the Constitution, the failure to modify violates that constitutional provision. Again, paragraph 68 of the said decision, it speaks about modification at page 32. Again, paragraph 73 at page 34, it speaks about the need to substantiate the motion. Again, Your Lordship, look at paragraph 115 at page 49. Look at paragraph 116 and 117 at page 50. The question of the status quo. what my learned friend was submitting to. That is to say, if the petition succeeds, we revert back to the status quo ante, and reverting to that particular position, no constitutional crisis will be occasioned, because we will be reverting to a situation that is consistent and known by law. It is them who believes that they are lawfully in office who may want to urge that particular provision, argument of constitutional crisis. There will be no constitutional crisis by saying that Kindiki is unlawfully in office. No constitutional crisis, but it's tend to believe so. Your Lordship, paragraph 134 at page 57, that speaks about public participation, Your Lordship. Again, look at paragraph 146, 148, 147, and 148. And finally, Your Lordship, I try to highlight what I find relevant. Look at paragraph 155 of the Constitution of the said judgment. And my Lord, it deals again with the issue of the failure to modify the rules. Your Lordship, I want to urge you to find that there was no impeachment at all, and that whatever happened at the Senate was a mockery of justice, a travesty to the Constitution, a violation, and it is amount to serious contempt on the part of the people of Kenya. Your Lordship, speak as if you'll never speak any other time. Your Lordship, speak for the people to hear. Speak for the people of Kenya. Your Lordship, the fate of this Constitution squarely rests on your hands. The fate of our democracy squarely rests on your hands. The fate of the people's power, the sovereignty of the people, and the ability of the people to govern themselves and decide the government that they want to be governed and the mode of governance rests on your hands. The baby is with you, Your Lordship. You may choose to kill it or give life to it. You may choose to pour the water with the baby or take care of this baby. This baby is only 15 years old, Your Lordship. The Constitution is only 15 years. Let it be preserved by your power. Most obliged.
Oh, thank you very much.
Good afternoon, Your Lordships and my lady.
Good afternoon.
Morara Omoke, counsel for the 43rd petitioner. The first thing is that, Your Lordship, you asked a question during the argument by the respondents on whether we can determine the quantity or the amount of public participation required in such a process. And I took some research for the court. I hope you can accept. I filed a list of the bundle of authorities yesterday, in which I tried to establish whether public participation can be measured. I will hand over to the court assistants. There are 3 copies for the court. And I hope I made the work easier for the court, the researchers for the judges. And I'll begin there to answer that question.
Well, we're grateful for the good job that Mr. Moke has done. We know him only to be an ever diligent counsel. But however well-meaning that is, I don't think that is material that can now be produced without opening up the hearing for us to respond to it. It isn't a unilateral interaction that can happen between Mr. Moke and the court. We object to the production of that material, but if your lordships decide to allow it to get on record, we would want an opportunity to consider it and to respond to it appropriately.
Your Lordship, before you go first, you allowed the counsels to file any further material that can assist the court in making its determination in this case. Secondly, they were given an opportunity to answer the question. How they answered, that was their choice.
I think that it's actually for us, the petitioners, to say that we also have a right to answer that question. Because I think when I heard the question, I knew that the court has nailed the issue.
Are there submissions?
There are not submissions, they're just, I'll explain them. So what I've provided here, I compiled.
No, the thing is, are they material which will, of necessity, require a response?
Is that if they wish to file more research for the court, the better.
I don't think that's a question that Mr. Omoka can answer, and I don't think it's fair to ask him whether it will require a response. It is for us to determine.
If there were submissions, they would not require a response because we gave directions for filing of submissions. So if there are no submissions, what do you think? Mr. Omoke, if there are no submissions, unfortunately, we cannot admit them at this stage.
Your Lordship, then am I allowed to answer the question you asked? How do we measure public participation?
Yes, that is, you are submitting, you are allowed to submit.
And my answer is based on the material in these documents.
But this is not the stage at which we can accept that material. I think you also know.
Your Lordship, just for record,
yes,
you actually ordered in the last time we were before you, that if there is any material that can assist the court, including the South African case.
But whichever material, that was good because we did it. But you see, every material must be responded to. If you file a material, it has to be responded to. And I don't think we are in a situation to adjourn these matters again for purposes of other responses.
Your Lordship, this is to help the court to answer the question. I believe that they can be allowed to file if they so desire. In fact, some of the documents I filed here, they are matters of judicial notice because they are documents, policy papers, from two of them from the Office of the Attorney General. And perhaps I think it's good for the court to have a look at the material as you decide that objection. Kindly.
Mr. Omoke, I think the court has already given its position. The materials are not submissions. Those are substantive documents, which by right the other party must respond to. So we've made a position, we are not accepting. If you have anything to say in submissions, maybe, but not in reference to those materials. Thank you.
Thank you, Your Lordship. So I will proceed to answer the question. The question the court asked was, how do we determine how much public participation is enough? And that question is important because we've looked at the judicial precedents that have come out of the courts, which have given descriptions. They have described what kind of public participation is expected of any process. To answer the question, I went back to Article 10 and I restudied the article. Actually, the language in Article 10, Clause 2, is democracy and participation of the people. That's actually the proper description of that value in Article 10. And there are other values, two others which have been named together, transparency and accountability. There's another one that has been named together, non-discrimination and protection of the marginalized. The reason being that why we conduct this participation of the people is actually to promote democracy, which comes from the word demos, the Greek word demos and kratos. Demos to mean the people, kratos to mean power or rule. For in the circumstances of this case, it is very easy to measure the public participation and determine if it is sufficient. Parliament has confirmed before the court that they collected views from 200,000 people. A matter of judicial notice, in the last election there were 22.1 billion registered voters. The number has increased a little bit at the moment, but going back to 2024 it was around that 22.1 billion. The population of the people in Kenya from the last census was about 55 million. Now it's about 58.5 million people. A quick calculation, if you take the 200,000 people, divide by the population, whether you work with 58, whether it's 58.5, it tells you that the Parliament was only able to hear from about 0.03% of the people. That's from a numerical standpoint. So when you go back to the decisions of these courts, of our courts on this subject, they have given a lengthy descriptions that the public participation should be real, it should not be illusory. I might also add the word, it should not be a chimera, it should be thorough, but we should be able to measure. Because also, as I said, it should not only be quantitative, but also qualitative. From a quantitative perspective, it should be so clear to the court that that is not enough. I'll still continue to look at that numerical issue. This country has 290 constituencies for purposes of electing members of the National Assembly. When you take the total number of people from whose views were collected, 200,000, and you spread out across the different 290 constituencies, that's about 690 people. I heard someone say it's a lot. It's extremely small. It's like a drop. It's like a sand particle in the ocean when you look at the full scheme of things. From a county perspective, 47 counties, 4,225 on average. I'll take an example of the county where I reside, Kiambu County, which has about 1.2 million voters. Again, an issue of judicial notice from the last, the data from 2022. If you hear from only 4,225 people, I think that's extremely small. So I'll ask the court to apply that test. Look at the numerical aspect. Then when you come to the qualitative, we have to question whether the views that were collected were actually incorporated. So what I'm actually asking the court to do is to develop or to order the various state agencies to actually develop an element of a public participation index or a people's participation index. How I wish the court would have allowed, or have agreed to look at that material. It would have learned a lot, but I'll take this opportunity hopefully one day to write an article. I don't know if any of our judges will agree to read with me. We can do an article on this subject, and it will totally help our legal system. And still on this issue of the participation by the people, how I wish that after the BBI decision was passed, that the courts above avoided to engage in an intellectual war, which in the end kind of watered down the gains we made before these courts. But very importantly, in that particular case, the court was able to consider the participation of the people at different stages prior to the making of a decision. Of course, going back now to the issue of qualitative, so that you do not come out with a decision, then you try to legitimize through a process before you incorporate the feedback of the people. So in the BBI case, which I'm very proud of, having participated extensively, we were able to show the court that when they went around collecting those views, when they went around the country, in the name of building bridges, they made which was supposed to be subject to the referendum. But we were able to show that that bill that they came out with was not a product of proper participation of the people. So that such that before they formulated it, they should have come out and said, after going through the various sittings, which were actually done, as I said back then, in the five-star hotels, when they went around and collected views for that report, the BBI report, and later decided to crystallize some of those ideas into the bill that was to be subject to the referendum, they should have actually come back to the people, hear from the people, and hopefully even collect views and refine the documents before it went through the various processes at the counties, the National Assembly, and which, as you remember those days, also we experienced a moment of magical speeds in this country when something was done with major level of efficiency by our parliament. They were required in the judgment that they ought to have collected the views from the people, refine the document, then continue the rest of the process. In the current case before you, it's not been disputed by any of the respondents that prior to the bringing of the motion before the National Assembly, there was no element of public participation. What actually ought to have been done by the 9th respondent, I believe, Mutuse, he should have started back at his constituency, get views, try to speak to the people before he crystallized the motion. That was not the case. In terms of processing the feedback of the people, once they conducted, later on when the National Assembly conducted the public participation, well, I believe it was done about 9 hours, for about less than 9 hours, when I counted the hours, at least they should have made an attempt to process the feedback and even refine the motion again before it was subjected to a vote, and then maybe if it went through, forwarded to the Senate. Which will bring me, as I close this submission, to the decision that was passed or delivered in this particular litigation, but in a different petition, E550 of 2024, by the Honorable Chacha Mwita, when he was making a decision on the request for conservatory orders. That's when the process was at the National Assembly. I hope that decision ought to be part of this record. There is something he said, which some of my colleagues have spoken to, that when it comes to constitutional violation, there is no violation that is beyond the reach of the Constitution. As long as an act is a violation, the Constitution will not spare. It cannot spare such an act. And that's when this court swings into action. This court it must intervene and declare any such act by the name it deserves. It's so sad that in this country sometimes the people who are in charge are people that hate the Constitution, hate the people. And what I'm asking the court is to do something which is simple. Protect the Constitution, for when you protect the Constitution, you protect the Republic. And when you protect the Republic, you protect the people. Thank you very much. And I'll ask my colleague to make a short submission as well.
Thank you, my lords, my lady. My name is Sasha Omai, and I'm appearing with my learned friend, Mr. Morara Omoke, for the 43rd petitioner. And I want to submit my rejoinder on two issues. First being the numerical threshold, and the second being the justiciability of impeachment proceedings. My lords and my lady, my learned friend, Mr. Moshemi, who appeared for the 9th respondent, heavily relied on the numerical threshold. However, I respectfully submit that the impeachment under Constitution of Kenya 2010 is not a merely arithmetic exercise. The attainment of numbers alone cannot cure a process that is unconstitutional, procedurally unfair, or a violation of the natural justice. And this, my lords and my lady, I want to quote Article 10 of the Constitution that obligates Parliament as one of the state organs to uphold the provisions. And I won't read because of the interest of time, and I am very determined to join Morara Omoke in the high regards he commands before these honorable courts in timekeeping. So I will not go into details. Article 47 that guarantees that every person has the right to fair administrative action. And in this case, numerical threshold cannot overlook these provisions of fair administrative action. And also we can read together with Article 47 to Sub-Article 2. Further, we look at Article 50 of the Constitution that secures the right to fair hearing, numbers notwithstanding. My learned senior, Mr. Masharia, tackled this extensively, and so I will not belabor that point. My lords and my lady, it is imperative to note that impeachment proceedings, though political in form, assume quasi-judicial character because they carry grave, and I quote the word grave, constitutional consequences. Under Article 75(3), it provides that a person who is dismissed from office for contravention of the Constitution is disqualified from holding any other state office. My lords, my lady, this is too much for one person to bear. As aptly put by my learned colleague, Mr. Ndegwanjiru, adherence to Article 150, 1 and 2 of the Constitution is very necessary in this case. Consequently, the process must not only satisfy the threshold requirements under the Constitution and standing orders. We relied on Standing Order 64, going on, that guides the National Assembly, but must equally comply with Articles 10, 47, and 50 of the Constitution. My lords, in this case, I therefore submit that constitutional compliance cannot be determined solely by the numbers of votes garnered, but whether the entire process met the constitutional standards of fairness, legality, due process, and rationality. A violation of the Constitution, constitutional safeguards, cannot be legitimized by a majority vote. So, my lords and my lady, I urge this court to uphold constitutional supremacy, which is enshrined under Article 2 of the Constitution, by ensuring that all organs exercise their powers within the ambits of the Constitution, and that is not, and this does not amount to an assault on parliamentary independence, as that was the fear expressed by our respondents, the good Professor Gedo Muigai and my teacher, Dr. Mudomi Giankoro. My lord and my lady, it is important to note that constitutional compliance is not determined by the loudness of numbers, but by the fidelity to the due process of the rule of law. Secondly, my lords and lady, numbers may satisfy the threshold, but fairness confers legitimacy. Overwhelming support, political support cannot legitimize a constitutionally defective process. And in this case, we have established there's a flaw in how the process was carried. Lastly, on that, the constitutional legitimacy flows not only from the numbers, but from strict adherence to constitutional safeguards and due process. The majority support cannot sanitize an illegality. I would want to quote the case of BBI, where my learned friend, Morara Omoke, was a great patriot, was both a party, a key party, and council. The High Court emphatically held that constitutional compliance cannot be satisfied at the altar of political expediency or numerical strength. And my lord, because I know in this room we both love football, most Kenyans do, I would like to liken reliance of parliamentary arithmetics to a football match, where one team scores more goals but referees ignores the flaws, denies penalties, and applies rules selectively. The score may stand on paper, but the integrity of the match is compromised.
Can you cite authority for that one?
That is an analogy,
Yes.
my lord.
Which teams are you referring to?
Arsenal, we are currently celebrating a big win. So I'm in that spirit, my lord. In circumstances, I respectively submit that numbers alone do not confer constitutional legitimacy where the process itself is fundamentally flawed. On my second issue, my lords and my lady, the learned senior counsel, Professor Gido Mugai, made heavy weather on, I use that word or phrase because he likes it, arguing that impeachment is a purely political question, and further goes to qualify it as a sui generis process to mean one of a kind. I want to put it to this House, to this honorable court, that once constitutional rights and procedural fairness are implicated, the court has jurisdiction. Courts are not being asked to decide politics, but constitutionality. It is clearly stipulated under Article 1.3 of the Constitution that Parliament exercises delegated sovereign power, therefore remains constitutionally accountable. Delegated power does not give absolute power. It is not absolute power. Article 3.1, every person has an obligation to respect, uphold, defend Constitution, right together with Article 22.1, which gives every person the right to institute court proceedings if the rights and freedoms have been denied, violated. This petition, my lord, my lady, is not an exemption. Article 165 of the Constitution, under subsection 2b, this court is bestowed jurisdiction to determine whether a right or a fundamental freedom has been denied or violated. I'll quote the BBI case. It was settled with finality and clarity, and it was held that political questions do not become immune from judicial review simply because they are politically sensitive. It is further quoted. The provisions under 165(2)b are stated above, which gives this court jurisdiction to determine the question on fundamental and Bill of Rights. Every exercise of power is reviewable for constitutionality. And the doctrine, which has been relied on, of separation of power, does not erect a constitutional no-go zone or immunity from judicial scrutiny. Finally, my lord, my lady, I want to rely on the case of Gachagua versus National Assembly and 3 others. That is under the petition A550 of 2024, read from section number 76 to 85. And the Article 2 is quoted that reminds everybody and everyone that Constitution is supreme and binds all persons and state organs at both levels, while Article 3 places an obligation on every person to respect, uphold, and defend the Constitution. Article 10, on values and principles of governance, is also mentioned, is also provided for, that public officers and all persons, whenever they discharge their mandate under this Constitution, must be guided by that article. And then also Article 163 that gives this court mandates will come in. Article 165.3, it gives this, it states on how this court can have mandates or make to scrutinize on constitutionalism in this issue. Lastly, the respondent cannot shield constitutional conduct behind the veil of a purely political process. While politics may form the background of the dispute, the moment legality, constitutionality, and due process arise, the matter ceases to be purely political and becomes a question fit for judicial determination. I implore these honorable courts to uphold the Constitution which is its primary mandate, to decline jurisdiction merely because the dispute has political implications would amount to abdication of constitutional duty. Accordingly, I submit that the objection on justiciability is without merit and ought to be dismissed. On this, my lords and my lady, I submit, and I implore these noble courts.
Thank you.
My lords, your ladyship, one of the issues that this court is being called upon to decide and determine is whether the first petition was accorded a fair trial in the impeachment proceedings by the Senate. And this court has had respective arguments and submissions. You will recall Senior Counsel Dr. Kulu advancing the argument that the first petitioner was accorded a fair trial by saying the affidavit by the first petitioner in the Senate was adequate, that in fact it is the National Assembly that was deprived of the right to cross-examine the first respondent. And that is the issue I would like to reply to as an issue of law. First, Article 50, Subarticle 1, applies the right to a fair trial to quasi-judicial tribunals and bodies, so that Article 50, Subarticle 1 applied on all fours to the Senate when it was conducting the impeachment proceedings. Permit me also to draw this court's attention to Article 25. The people of Kenya, when they gave themselves the 2010 Constitution, considered the right to a fair trial so fundamental that they included the right to a fair trial in Article 25 as one of those rights that cannot be limited. Shows the importance of the people accorded the right to a fair trial. It is my submission that central to the right to a fair trial is according a party the opportunity to go in the witness box, take the Bible or the Quran, and give oral evidence on oath. It is not enough to say you have filed an affidavit. How many times has this court and other tribunals changed their minds by observing the demeanor, the body language of a witness answering questions in chief, in cross-examination, and in reply? It's a fundamental right. The first petitioner, His Excellency Rigathi Gachagua, wanted to have that opportunity. He would have been led in chief to respond to all the false allegations in the 11 charges that we are facing. He would have been led in chief. He would have given that evidence. Number two, he would have had the opportunity in cross-examination to demonstrate to the senators, because of his veracity in answering questions, his demeanor, his body language, when answering questions in cross-examination, would have been an important attribute of that right to a fair trial, including replying in such a fundamental matter as removal from office as Deputy President, having been elected by over 7 million Kenyans. That right to a fair trial, the denial to accord him that opportunity, amounted to a gross violation of his constitutional right to a fair trial. And, my Lord, your leadership, this point, this submission that I'm making about the importance of the tribunal, the Senate in this case, having the opportunity to see the veracity is a witness prevaricating, hesitating in answering questions, or is he confidently answering the questions without hesitation? That opportunity for the first petitioner here to have persuaded the senators, irrespective of the affidavit. That opportunity, this is not the first time that that issue is being raised here before this court as an afterthought. I invite this court, when it retires, to look at the Hansard, which is annexed, the Hansard of the Senate for both 16th and 17th of October, is annexed to the affidavit of Mr. Nyegenye, the clerk to the Senate. The proceeding, the Hansard proceedings for the 16th are in Battle 1. The Hansard proceedings for the 17th is Battle 2. Both are next to that affidavit. And when you retire, go through it, and you will see that I drew the importance of oral evidence on oath to the senators. I say at page 12652 of that Hansard record. I say point number 2 is the importance of honorable senators to see with their own eyes how a witness withstands cross-examination. There are many times when different impressions will be given by a written document, and yet when cross-examination takes place, individuals change their minds. One can only make a decision on whether this witness is believable or not when they see his demeanor in person. There is nothing to replace orality through cross-examination. There are many witnesses whose statements will be impressive, and yet when they begin to give evidence orally, that impression changes on the mind of the jury. The Deputy President wishes to subject himself to cross-examination and on oath to deal with the evidence given adverse to him by witnesses here, so that honorable senators can have an opportunity of making a decision. Is it the Deputy President they believe, or those other witnesses? That opportunity can only come through orality and cross-examination. what this House elects to do, they will make that decision on Tuesday, because the first petitioner was applying for adjournment until the following Tuesday. And I said I'm always an optimist. I'm living in the belief that the doctors will be able to put whatever is wrong with the Deputy President, will be able to put it back in place so that he can be here on Tuesday. If he's not here, let the decision of what this Honorable Court will then do be made on Tuesday. That is a humane way of going about a matter about which no one had any control. And for the Senate to have deprived that opportunity to the Deputy President, the first petitioner, on the basis of their misreading and misapplying Article 145, and of course not taking into account Article 150, that they had to conclude the impeachment within the two hearing dates, 16 and 17. At a time when the Deputy President had been taken ill and admitted into hospital. That, in my submission, amounted to a gross violation of his right to a fair hearing by a quasi-judicial body, the Senate, which could not even be limited. And, my Lord, Your Leadership, I was not the only one raising that issue. When you go through that Hansard report, page 12677, you will see the senator for Nandi County, not the county of Nairobi, or the county of Kisumu. He actually agreed with me. You will see what he says on record in the answer. As I begin, I want to wish my brother and friend Rigathi Gachagua a quick recovery after that unfortunate incident. The ongoing process has largely gone on well until the adherence of Article 50 came up. And he goes on to say, we have not succeeded in giving a fair hearing to the Deputy President. That is after he had quoted Article 50. The reading of Article 145.4 does not specify the timeline in which the Deputy President's removal can be listened to. It is only by a special committee that it provides for 10 days. So that was very unfortunate in the principle that justice should not only be done, but must be seen to be done. Many Kenyans are asking questions. That is a senator contributing from the floor of the Senate. And let me make this submission. There was never any issue in the Senate on the 17th when I informed the Senate through the Speaker that the Deputy President had been taken sick and was in current hospital. No one raised any issue whatsoever. In fact, if there was time, I would have taken the court through the contributions by members, but permit me to invite the court to look first of all at the Speaker of the Senate, what he said on that 17th. Speaker of the Senate who speaks for himself and for the House. And the Speaker said, honorable senators, ladies and gentlemen, In conclusion, let me take this opportunity on my own behalf and on behalf of the Senate to convey our sincere sympathies and wishes for quick recovery to His Excellency Rigathi Gachagua, AGH, Deputy President of the Republic of Kenya. That, I submit, should be accorded weight by this Honorable Court because it is the Speaker accepting that the Deputy President was sick and wishing him quick recovery. And he was not the only one. As I said, I'm not going to read through, but the minority leader, Senator Madzayo, also sent good wishes for quick recovery. Napeana pole zangu kupitia senior counsel, yours truly, kwa sababu client wako ni mgonjwa. Ugonjwa sio jabu. Ugonjwa ni jambo la Mwenyezi Mungu. Hatuwezi kusema kwamba mtu hawezi kuwa mgonjwa. Mtu yoyote anaweza kuwa mgonjwa. Kwa hivyo ningependa afikishe pole za Senate. Tunamtakia kila heri, Mwenyezi Mungu ampe nafuu ili tupatane tena. And there are many other senators who sent their wishes, so that the summary is this: the issue of the Deputy President having been taken sick, and he had attended the full day the previous day, 16th of July. He had attended the whole morning of 17th. He only fell sick at lunchtime when he was rushed to hospital. But the point I'm making here is that that was never ever in dispute whatsoever. It was accepted, and because the Senate was a quasi-judicial body, they could have sent their own doctor to Karen Hospital to confirm that the Honorable Rigathi Gachagua was indeed unwell and in hospital. And, my Lord, I made that very, very clear. You will see from page 12648, when I addressed the Senate again through the Deputy Speaker. And I said, Mr. Speaker, sir, I would like to inform honorable senators. My Lord, I'm responding on the issue of a fair trial. To deny somebody an adjournment when that person is admitted sick was a gross miscarriage of justice, a violation of his constitutional right. I don't know. I suspect he just wants to interrupt a point that perhaps
no, the point, my Lord, is, Honorable Muite is a very senior lawyer. We honestly wouldn't want to interrupt his presentation, but he's making his reply as though he's arguing and cashing his case afresh, taking it through, I don't know who said what, which aspects of evidence. It is not another bite at the cherry. I have really, we have consulted here, and it is with a lot of restraint we are forced to make this objection.
That is my pupil must have avoiding raising those issues. But when you read statements, when you read renditions and contributions from senators, including some in Kiswahili, which he incorrectly reads, it is difficult for us to have an opportunity to respond to some of those factual issues which are not legal issues. He can respond on the principle. We are not going on the principle of fair trial, but let him avoid those speeches, especially, and even from Ferrari.
No, citing anything you said in the Senate deliberately. But, my Lord, Your Ladyship, you will remember my good friend here, Senior Counsel, in his submission, he said that the Deputy President was faking illness. He wasn't sick. That is the point I am replying to. It's an issue of law. Was he given a fair trial or not? Obviously, if he was faking sickness, then one can argue that he was not, his rights were not violated. So it's very, very important on that issue. And my submission, the Senate never raised on the 17th of October any question as to whether or not Rigathi Gachagua, His Excellency, was sick and was admitted. That is the point, and it is this answer, it is them. Professor Tom Ojieda is leading Mukele, Moni, and Associates. They are the ones who filed this answer. It's part of the record before this report. What harm is there in my strengthening the violation of the constitutional right to a fair trial to a person who is in hospital? And permit me just to draw your attention to it. I said I would like to inform honorable senators that I have been able to contact the doctors at current hospital. There is a team of doctors who are looking after the Deputy President because of his condition. I was not able to directly talk to him on the advice of his doctors. They say he must have complete rest for the time being. However, I was informed by his doctors that he is currently suffering intense chest pains, and I did not want to inquire further. I plead with the court that you read through that Hansard all the relevant pages. There are many, many senators who asked me to pass wishes for speedy recovery. Now, for him to have been deprived of that right, of being led in, being cross-examined, answering this question, he would have had the opportunity, for example, to address the false allegations that were made by Senior Counsel Dr. here, that he had grabbed the estate of his brother, ground 8, without any substance. If he had been given that opportunity, he would have been able to demonstrate. And actually, he had it. That the will was forged even before his brother's body had gone cold. Vitriol dressed in eloquence. It doesn't translate into truth. These are issues that Gachagua would have been able to address. His right to a fair trial was grossly violated. And I ask this court to ignore that vitriol. Just like I ask this court to ignore Dr. Thionkuru, my friend, attempting to make a mountain out of a molehill on the basis of the initials RG. Always, this very court does not put the full names of parties to a divorce case in the divorce file. No, they put initials. Why? To respect the constitutional right to privacy. Nothing wrong. And Dr. Gikonyo was here with his file, with the document. I actually expected my colleagues on the opposite side to ask Gikonyo to table the documents he was being accused of not having annexed. He was never asked to table anything. The second point before Professor Tom Ojieda now jumps up a bit my submission, the reason for this political doctrine being pushed on this court by the Attorney General through Senior Counsel Professor Rigathi and the Senate through Professor Tom Ochieng. The real reason is that they don't want this court to evaluate the evidence presented by Mutuse in court. They don't want you to examine the record, Hansard, of the cross-examination of Mutuse, who was the primary witness, cross-examination by Senior Counsel Elisha Okoya. Why are they trying to stop this court from doing that? Because they know that if this court does that, the court will come to the inevitable conclusion that there was here no evidence to form the basis of conviction of even a simple traffic offense, leave alone impeachment of the Deputy President. That is why they are telling this court that on the basis of that doctrine, political doctrine, your mandate is to check whether the procedural aspects were complied with by the Senate and by the National Assembly. Procedural aspects. But don't go further to examine the evidence. Lord, my answer to that is that there are many cases by the High Court, by the Court of Appeal, by the Supreme Court, including the Sonko case and the Wafora case, in which these courts have asserted their jurisdiction. Second point I'd like to make, my Lord, again, the people of Kenya, when they gave themselves the 2010 Constitution, and I invite this court to have a look at Article 1 and Article 2. Article 1 about sovereignty, Article 2 about everybody, every institution, government, being bound by the Constitution. The people of Kenya made two important decisions. First of all, it is not by accident that Article 1 was placed as Article 1 and Article 2 about the supremacy of the Constitution was placed as Article 2. It was because of the importance of the Constitution. So the point I'm making, the submission I'm making here, is that the people of Kenya made two important decisions. One, they placed their confidence, their total trust in the Constitution. They did not place that total trust in the executive, in the National Assembly, or in the Senate, in the Constitution. That's what they did, Article 1 and Article 2. The second important decision they made was that they, the people of Kenya, by ratifying that Constitution, said in Article 165 that it is the court, they placed their confidence in the judges of the High Court to interpret and apply the Constitution and decide whether anything said to be done under any law was done within that law or not. That is a jurisdiction, that is a power that cannot be taken by this court for whatever political considerations there might be. My Lord, the 10 days limitation, even on a plain reading of Article 145, was in sub-article 4 limited to the the special committee doing the investigations. As far as proceedings in the plenaries are concerned, they would have proceeded on the basis of Article 159, sub-Article 8, where no time is prescribed. That thing will be done within a reasonable time. And my Lord, even the Speaker of the Senate had at least agreed to adjourn until Saturday. That motion was moved, put to the members, the senators. They voted against even adjourning to Saturday. And they proceeded. A person sick in hospital, they proceeded. That was a gross violation. So on the basis of the political question, on the basis of a fair trial, this is a petition that I plead this honorable court should allow. Permit me to say only one word about public participation, and which is this: that given the importance of Article 1, Article 10 and Article 118 on public participation assume greater significance in impeachment proceedings because the sovereignty is vested in them. And the public participation here was quite simply a sham. My Lord, the first petitioner looks up to you to do him justice that was denied him in the Senate impeachment proceedings. That is what the people of Kenya, because it is them who are sovereign, it is them who distributed these jobs, that is what this case is all about. It's beyond being about. And finally, on the issue of emoluments, you've been addressing about that. This is not a simple employer-employee case, as was the case with the telco. This is a petition of an elected official governed by Article 20. Article 23. The award of damages. You call the right to award damages. It is Article 160. It is 160. Yes, it's Article 23. Where the court is given specific jurisdiction to award damages. So I plead that you permit this petition, which will set the president not just for Rigathi Gachagua, but for future impeachment. I thank you.
Thank you. Thank you very much. We have come to the end of the proceedings for today. Now reflecting on what you have been submitting upon since this proceeding started. You've been urging us, telling us that when you retire, when you retire, now we are retiring. So we will then retire and prepare judgment to bring these proceedings to a close. And we hope to do that on 8th of June 2026 in the ceremonial hall at 11 a.m.
Perhaps before you do that, I have one issue that I just want to bring to the court's attention and make a suggestion that should hopefully make everybody's life a lot easier. But there is the other cohort of petitions in this matter, cohort of petitions that were filed prior to impeachment, and it has a hearing date for Tuesday, Wednesday, and Thursday next week. But my suggestion is as follows. The issues in this matter, both cohorts, have been argued exhaustively in this matter. My suggestion, and I believe I speak for many of my learned colleagues, is that the hearing of those cohorts of petitions be penned and be mentioned after the judgment in this one has been delivered, and we can see if there is anything that remains for determination.
I think that's a good observation. That is the way it's going to be. Any proceedings in these matters will give directions of CTS on how they will proceed, but certainly will be mentioned after we have delivered judgment in this matter. So we'll give directions in the CTS.
On the date that they were scheduled to begin.
They will stand adjourned, but we'll give directions on CTS so that we are clear that parties know the directions that are given. For the parties who are here, I think the information is that they will stand adjourned until we give a mention date for them.
We accept it.
But for purposes of everybody getting to know, we'll send the information on CTS on every file. Yes.
I'm only raising that issue because while I agree entirely with what my namesake has said, it is best that we proceed in the manner the court has suggested because there are some individuals in that cohort who are not parties in this second cohort. Of course, they need to be present when whatever decision is made.
Thank you. I think we just give directions.
If I may, my is in Paris of Kinyanjuri. I'm in petition 586/2024. It's wholly outside the courts, and yet it raises issues that are implicated here. We have a hearing date on the 4th of June. That's before the judgment date that has been given. With tremendous respect, my lords and my ladies, the issues raised in that petition are very weighty and equally implicate these particular proceedings. So that your lordship, I don't know between the 4th of June and the 8th of June, a judgment in that 586 can be rendered. Because your lordship, your lordships and my lady, my client would stand wholly prejudiced in the circumstances of adjournment without a hearing on a standalone petition.
Mr. Kinyanjui, I think you are misinformed. Your matter is coming for a mention, not a hearing. It's coming for a mention on that date.
We got a hearing.
But
we got a hearing.
Yes.
Hearing date.
Let's make it clear. Let's make it clear that these matters are related. All these matters are related, and for the time being, we are rendering a judgment on the current petition on 8th of June 2026. All other matters related to this matter, we are going to give directions on CTS. Thank you very much.
My lord and my lady, petition 586 say read this petitions.
charge for court of appeal.